In this video, I am going to explain about the scheme of the Indian Contract Act 1872. The contract, the law of contracts in India deals under the Indian Contract Act 1872. The Contract Act broadly divided into can be divided into two parts. In that first one, the general principles of contracts. What are the basic and essential principles are involved to make a contract or during the contract any transaction? That will be the part 1 of the Indian Contract Act. And the second one will be specific kinds of contracts. So nothing but special types of contract. Coming to the first one, general principles of contract. The general principles of contract may be studied under three broad headings that are as follows. Already you can observe that under the general principles of contract, section 1 to 75. In that the first one can be maybe formation of contract, how the contract can be formed, and second the discharge of contract, and third one remedies in the event of breach of contracts. What remedies are available to the party when other parties breach the provisions of the contract? That all will comes under, can be considered in first part of the Indian Contract Act. Coming to the second part, the special contract or specific kinds of contract, section 124 to 238. Under the specific or special contracts may be categorized as 1. Contracts of indemnity and guarantee. Contract of indemnity and guarantee, sections 124 to 147. And second, contracts of bailment and pledge, section 148 to 181. And third one, under the special contracts, contracts of agency, section 182 to 238. If you observe this categorization, the first category general principles will be section 1 to 75, and second one section 124 to section 238. In between, section 76 to 123 of the act were repealed in 1930, and a separate act was enacted to deal with sale of goods, which is known as the Sale of Goods Act 1930 and the Indian Partnership Act 1932. So that sections 76 to 123 was repealed, and in place of that a new statutory act was enacted. That one of that act is the Sale of Goods Act 1930 and another one is the Indian Partnership Act 1932. Once you observe that case laws, Bhagavan Das, Govardhan Das, Kedia versus Giridharilal Purushottam Das and Co. This is the 1966 case. In this case, it has been held that in the administration of the law of contract, the courts in India have generally been guided by the rules of the English common law applicable to contracts, where no statutory provision to the contrary is in force. In absence of statutory provisions, the Indian courts can implement the English common law, which is related to the law of contracts. And another case law, that Superintendents Co. of India versus Christian Murgai in 1980s case. In this case, the Supreme Court has been held that the English law is not relevant. The English law is not relevant on such aspects of the law of contract as are expressly dealt in by the Act, where the provisions are available in Indian Contract Act. In that particular case, the English common law can't be applicable. It can't be involved to deal that particular issue of the law of contracts.